Welcome back to the second segment of this law session on English legal system. Before the break, of course, we looked at one of the main sources in respect of the legal system in the UK, and that was, of course, EU law. And the reason I consider it a main source is that it has taken on a more dramatic life in recent years than it would have thought, because the idea is that EU law has impacted so much that when you look at the whole idea of being part of Europe, the UK has had to take on a framework which before it wasn't used to. So now what we see is an extraordinary amount of EU law by virtue of the case law coming out of the Court of Justice of the EU, which impacts UK law. So do bear that in mind. Of course, we do touch on this again at a later stage, where even when we look at precedent, but the idea is that never forget that Parliament is supreme, and that therefore brings me into statute law. All right. When we look at statute as a source of law, now statute is an act of Parliament, statute is legislation, so you use those terms interchangeably when I use the word statute. Now the idea, of course, is that Parliament is supreme. When you look at the framework of the UK, when you look at the organs of the state, there are three organs of the state, as you may well know. You've got the legislature, the judiciary, and you've got the executive. Now, the executive deals with policy. This is the cabinet. You have Parliament. Parliament legislates. You have the judiciary, and the judiciary, of course, interprets the law that the legislature legislates on. Now, the idea within the context of the UK is that because it does not have a codified constitution, then Parliament is the supreme lawmaker. So Parliament has what is called legislative supremacy. So the idea is that Parliament makes the laws, the courts interpret them. So when you look at laws in the UK made by Parliament, what then is Parliament? Parliament in the UK consists of a bicameral chamber, meaning two houses. And again, most Commonwealth, and in fact most democracies tend to have a bicameral chamber. You can, of course, have a unicameral chamber, which is just one single house. Now, in the UK, there's the House of Commons and the House of Lords, and indeed, the monarch is in that mix as well. Now, the House of Commons is the main house because they are elected, of course. And then you have the House of Lords, who are appointed. And you have this whole concept of the House of Lords originally being predominantly persons who had a seat in the House of Lords by virtue of their birth. So they were called hereditary peers, peers being merely another meaning for a lord or the like. But you had a number in there who were, of course, also appointed. Now, with a big, massive reshuffle in 1999, we had a massive reduction in the number of hereditary peers, because the question is, why should you be the government simply by an accident of birth, as it were? So what we get now is an upper house, which is the House of Lords, which has a huge appointed majority. Now, in Britain, when you look at Parliament, it is sovereign, as I say, and this has traditionally meant that the law it makes takes precedence over law originating from any other source, including, of course, the EU. Now, the idea behind that is Parliament is supreme. Now, EU law only has effect by virtue of the European Communities Act. Because of legislative supremacy, if Parliament tomorrow were to repeal the ECA, the European Communities Act, then EU law would not have the effect it currently does. So bear that in mind. Parliament, of course, can make or alter or cancel any law, and the courts, of course, must enforce it. Now, coupled with this is the conventions, and in English law, you have what are called non-legal rules. And these non-legal rules are followed. So, for example, when you look at an act of parliament, it starts life as a bill, it ends up as an act when the monarch gives it royal assent. Now, there's a non-legal rule, a convention, that once it has been through both houses, the monarch will give it the royal assent. So the rule is that they will give it anyway. Equally, there is this idea that Parliament can not bind its successors, meaning that a subsequent Parliament, so as to limit their legislative powers. Now, when you look at this inability to bind their successors, it means that if a piece of legislation is passed today, if a statute is passed today, a later Parliament can repeal that. You can't make an act, for example, that says you can't ever repeal that act. Well, you can make it, but it won't have any effect whatsoever, because as much as an act of Parliament is made, a subsequent act of Parliament can get rid of it. Now, when you look at the legislative process in the UK, although the English legal system is a common law one, and although these courts still have an important role to play in the interpretation of statutes, legislation is the predominant method of lawmaking when you look at the UK. Now, it may be necessary to have a working knowledge of the legislative process. You need to know how the whole thing works. Now, before any legislative proposal, a bill can become an act of Parliament, which is that it must go through and be approved by both houses of Parliament, and it must receive the royal assent. Now, the ultimate location of power is in the House of Commons, which has the authority because it is a democratically elected institution. Now, a bill must be given 3 readings in both the House of Commons and the House of Lords before it can then be presented for the royal assent. Now, it is possible to commence the procedure in either house, but when you look at money bills, they must be placed before the Commons in the first instance. Now, the actual preparation of bills are done by expert draftsmen, meaning people who draft bills, and they are known as Parliamentary Counsel. Now, when a bill is introduced in the Commons, it goes through 5 distinctive procedures. It goes through a first reading. Now, a first reading is a purely formal procedure in which the title is read and a date is set for its second reading. Now, in the second reading, the general principles, as it were, going on from where you're seeing the first reading, is that it is now subject to extensive debate, and it is at this critical point that the process becomes important. Now, at the end, in the second reading, a vote may be taken on the merits, and it is approved as the case may be. Now, it then moves on to the committee stage. Now, if you imagine that Parliament could not, of course, sit and listen to every single piece of legislation or every single bill that comes through, you have to consider the committee stage. This is where the bill is passed to a standing committee whose job is to consider the provisions of the bill in detail, clause by clause. Now, the committee has the power to amend it in such a way to ensure that it conforms with the general approval by the House at that stage. Now, it then moves on to the report stage, and at that stage, the standing committee then reports the bill back to the House for consideration of any amendment. It then goes through a third reading, which is a further debate, and of course, when it has passed all these stages, it goes to the House of Lords, and then of course, it goes through a similar process in the House of Lords, and then of course, once that goes through, then what you have is the bill moving into becoming law. Now, since the Parliament Acts of 1911 and 1949, the blocking power of the House of Lords has been restricted, because the House of Lords, of course, could block a bill when it goes through its own process, which is similar to the House of Commons. It could block a bill. It could decide that it is not going to pass a particular bill. Well, its blocking powers has been restricted in 2 ways. First of all, when you look at a money bill, which is one that contains only financial provisions, then it can be enacted without the approval of the House of Lords, by being delayed for 1 month. Secondly, any other bill can be delayed by 1 year and it would still be passed. Now, we have seen various situations where where acts have been passed, where they've used this parliamentary procedure by virtue of the House of Lords not, for example, agreeing. And the one that springs to mind, of course, is the Hunting Act, 2004 is one to look at, because, again, there was some intransigence when it went before the Lords, but by and large it was eventually passed. Now, the royal assent is required before any bill can become law. This is not a constitutional rule, it is a convention. It comes into effect when, for example, the bill, of course, comes into effect when, for example, it is been given the royal assent. We now have an act of parliament, and of course, no one can then question that act of parliament. Let's look at the some classifications just for your own understanding. A public bill is a bill that relates to matters affecting the general public. Now, these can be further subdivided into either government bills or private members' bills. But a public bill or a public act relates to acts which deal with matters which affect the public. Now, when you look at a private act, this relates to the powers and interests of particular individuals or institutions, although the provisions of statutory powers to particular institutions can have a major effect on the general public. So, for example, in times gone by, where persons, for example, needed, where the law said a particular thing, and I'm thinking of a family law situation, where it used to be that you couldn't marry persons within a certain degree of relationship. Now, let's say you wanted to marry your sister-in-law or your mother-in-law, and there really isn't any problem with that, except that there's an act that says that you can't. You may, of course, have a private act before Parliament which may amend that, but it has to do with specific things and specific individuals. When you look at, for example, the Lloyds Act is one that I'm also thinking of, which deals with Lloyds of London and the way this whole insurance situation works. That's a good one. Another way to define, of course, is enabling legislation. Now, that is where an act gives power to a particular person or body to oversee specific details of delegated legislation. So you can have a piece of legislation, a statute, and it's an enabling act that allows another, say a minister or a body, to then pass delegated legislation. You can have consolidating legislation. This is where you bring together previous provisions of a variety of acts and pull them together. Now, the Companies Act 1985 is an example, as it brought together provisions contained in numerous amending acts which had been introduced since the previous Consolidation Act of 1948. Codifying legislation may be legislation to codify a particular matter. So when you look at the Sale of Goods Act, for example, amending legislation is designed to alter some existing legal provision. Or you may have delegated legislation. Now, delegated legislation, as we flagged up, is where, for example, you have an enabling act. The enabling act gives power to allow a body to make laws under statutory instruments, orders in council, bylaws. It allows a body to make certain types of laws. So when you look at, for example, the Local Government Act of 1972, it is a piece of enabling legislation that looks at allowing local governments, for example, to pass bylaws. Professional bodies may be able to pass codes and other things. So when you look at, for example, the Law Society or any other type of bodies such as that. So the Law Society, under the Solicitors Act of 1974, they control the conduct of practicing solicitors. Now, when you look at delegated legislation, it does have some advantages. It does save time, for example. So you don't need all of this a piece of legislation before Parliament, it does allow access to particular experts and allow their expertise in that regard. But the point is that you have to be careful, because delegated legislation also has its drawbacks. It may, of course, be flexible insofar as an advantage, but when you look at the accountability, that may cause some problems, because you may get a body who just picks up this piece of enabling act and decide to pass legislation which goes beyond its powers, and then of course you will have to bring an action because of course they act ultra vires, meaning that they've act outside their powers. Scrutiny is of course a problem sometimes, and the prevalence, the amount of delegated legislation may be a lot to wade through. The good thing, of course, is it does take some of the pressure off Parliament, but the fact is that by virtue of its bulk, it may actually end up not being a great thing as it should have been. What it is for you to do is to consider, of course, the strengths and weaknesses, looking, for example, at the types of controls over it. Now, Parliament has a control over it, the courts have a control over it. If it gets too bad, Parliament can pass an act. If it is that a body has acted outside its power, then you can have the court, by way of judicial review, ensuring that they don't. So that, when we look at statutes as a basis, is one other source of the law within the English legal system. I'm going to take a short break there as well, and then when we come back, we will carry on in looking at the sources of law within the UK, and certainly we will pick up on things like cases, of course, and then we move on to customs.